MenzGold latest development. We just want to say good morning to you, first of all. Mr. Martin Kpebu, thank you so much for your time here on the Super Morning Show.
Good morning, Amazi. Good morning, Winston.
Good morning, Martin.
All right, Martin, I just want you to take a listen to this first.
Okay.
From 14th August to 14th September will be for the verification. On the 14th September, the verification, the portal would close. So we'll commit one full calendar month again, as in from 14th September, to the following 14th, to address all these challenges. Then on the 20th October, we'll dish out the first batch of payment, and then it will continue in that mode and manner until the last man is paid. We kindly and then respectfully entreat every customer, every person that believes they have genuine claim to exhaust the DD, this due diligence process. Please, if you think you have a genuine claim and you really, really, really want to get paid, kindly exhaust this last phase. Discharge this obligation and leave us to, do our part. No, after 1 month is done, and the window would be closed. Yes, it means that your DD didn't check out, your due diligence you didn't pass due diligence, and if you don't pass due diligence, it's an administrative, operational tendencies. If you don't pass DD, nothing can be upheld or sustained.
So, Martin, first of all, how can a man who has been charged with abetment, defrauding by false pretense, carrying on deposit-taking business without license, unlawful deposit-taking, money laundering, amongst others, how can he publicly come out and issue this statement, give this directive?
Yeah, so, obviously, or let me say it would appear that the regulators haven't spoken to him, because I expect that to the extent that he's not been able to, pay those customers and is facing charges, there should have been an agreement of a sort, even short of liquidating the company, that he should not carry on business, because he has to be sensitive to the plight of the customers. So for him to, go about doing these things as if nothing is at stake tells you that then our regulators are a bit behind. And even in that respect to the prosecutor, right? Because I expect that to the extent that he's ruined people's businesses, he's ruined people's lives, some have died, etc. And so thousands are in pain and grieving. The least he could have done should have been quiet. If he really got genuine money, it's not rocket science to expect that he would collaborate with the Securities and Exchange Commission, the prosecutor, and then the registrar of companies, for them to lead the repayment. Yes, because he himself, his credibility is gone. So he shouldn't be the one telling people to come directly for their money. No, because of what he's done, it should be clear to him that he shouldn't interact alone with the customers. Get the registrar of companies involved. Get the Securities and Exchange Commission involved, and then let's see how they help, so that they are the face of it. Then there's credibility, and also and especially as part of that credibility, we'll be sure that there won't be another scam. Because I don't know if I'm running ahead of myself, but you heard as part of this invitation, he said they should pay 650 Ghana initially, right? Mm-hmm. And it was clear that was another point in the making. You say, so we've left him too much. We've just given him too much room to operate. That he too should have some emotional intelligence, that he has ruined people, so he can't continue to do this. He paints the picture of a banana republic. Nothing works. Yeah.
Martin, talking about, wanting to take money. Yes, he's come back to say he's no longer going to, have those digital cards for 650. He's going to print, codes for free. But if you check and you are declared as invalid, if your application is invalid and you still want to pursue it, then it will come at a cost to you. The question is, who should be in charge of this? Where is the regulator?
Excellent. So that's it. So since maybe, I don't know, the regulators must be listening. The aggrieved customers must come together and go petition them. So the the part about deposit taking with our license. Yes, so you see the BOG and Securities and Exchange Commission. Yeah, so the aggrieved customers must petition them and also petition the prosecutor. So, and eventually that's the Attorney General, because all the cases are done in his name. And then the Attorney General is the one who prosecutes, even if sometimes it's given to the police, etc. Right? Yeah, so they should do multiple petitions and press regulators and the prosecutors to rein number one in.
But Martin, are we saying that without the customers petitioning these regulators, they don't see what is happening? They don't have issues with what he's doing now?
No, but from experience, Mama V, what I've seen is that because the problems are many, we have a myriad of problems. So the one who petitions and is constantly knocking at the doors of the regulators and the politicians get the most attention. Yes, that's the thing, because the problems are many, you see. So in that case, it's better you go constantly knocking at their doors to make the service better. Okay. Otherwise, you just think, oh, Ghana, or these guys, they'll make noise a little bit and then they'll just be quiet. Yes, that's the way it's seen at the other end. Yeah.
All right, this morning we're joined by Martin Kpebu, who's a private legal practitioner. We're having a conversation about Anapia Mensah, that's founder and CEO of MenzGold, as plan to pay his customers. But Martin, let me just find this from you. Now, this is a situation, he says, come and validate or you lose your money. First, you've talked about, the regulator being involved. But the question is, should people heed the call, bearing in mind what could happen to them?
Two answers to it. You see, ordinarily, if he has assets, you are not bound to verify, okay, come and validate, etc. Ordinarily, if we're using principles of contract. So that's to say, if you knew that, okay, look, he has X, Y, Z assets, you are not bound to go there. You are free to go to court. You can sue him in a civil court. But in this case, because it doesn't appear that he has enough assets to go around, that's be able to pay all the debts, practically, if the call to validate appears genuine, then it will be in the interest of the customers to go. You see, so yes, there's book law. We can say that the contract they signed, they didn't have such subsequent validation, verification, etc. Yes, that's it. Fair enough. But practically, if the call is genuine, the customers will be better off going, and it's quicker than suing. That's why I mentioned that. So he, number one, should have ceded grounds to the Register of Companies, right, and government. At a point, government, there are some news stories that showed years ago, government saying that his assets are to be liquidated and then customers to be paid, etc. So they should collaborate. If he has the money, he should let the Register of Company. I'm sure government will say the Register of Company should lead, because I know Register of Company has been in charge in paying some of the defunct microfinance companies, savings and loans, etc. Right? They've been playing a pivotal role. Or they'll get one of the big accounting firms to come in, like the way they did for the companies that had their licenses taken away unjustly, etc. Right? So on practical grounds, yes, customers should be willing to cooperate a bit, as long as they are not being asked to pay any more money or incur any other liabilities.
If they're asked to pay money, they shouldn't pay.
Absolutely. No more payment. No. Not at all. No more payment. And look, and number one should be clear to him that, look, it's common sense. If really he has money, considering what these clients or customers have been through these years, if you were to say at the point of payment, he's deducting 650 Ghana. Oh, my God. Come on, nobody will even bat an eyelid. They'll just take it and go away. They'll take the rest of the money and go away. Nobody will make noise. So the fact that Namwa is saying, he came out initially that come and pay 650 before you are validated, just sounded in another Ponzi scheme. Clearly.
Now, he has withdrawn that 650 Ghana cedi arrangement, but he still says that if people don't verify their debts with him by a certain date, then that debt ceases to exist. Is he legally able to do this? I mean, just in terms of law, can I, call my bank, for example, and tell them that if you don't convince me that I owe you by a certain date, then my debt to you will no longer exist?
No. Under principles of contract law, no, it doesn't operate this way. You see, sometimes there can be a unilateral offer, right? Those things. But in this case, they don't apply because in this particular case, there's already a contract between them. Those contracts the customers signed when they went and gave them their money, they invested their money. And so far, from my understanding, those are not provisions in that particular contract. Those are not provisions in the contract they've already signed. So, if that is not the case, and now you have money, you have to pay in a manner as not to violate the very contract that you signed. So that's why I mentioned earlier, Kojo, that instead of somebody going to verify with him in his company, the person may choose to sue, except that nowadays the suing option doesn't look attractive because, look, a good lawyer will tell you before you sue, usually one of the first things you'll be asking, that's if you want to recover a debt, is that, look, okay, when I get judgment and the person still doesn't pay, are there any assets I can fall on to sell? Yeah, because you go through the court processes and eventually there will be an auction of the debtor's assets. So number one's lack is that he doesn't have assets that people can readily fall on. It doesn't appear so, at least from where I sit. And so that's why he has an advantage practically. But he shouldn't abuse it. He should just be civil. He should be very sensitive to these customers. You don't burn your bridges. It's number one thinking, I mean, who knows? Perhaps you live another 50 years. He doesn't think about tomorrow.
Martin,
because today he has an advantage. He wants to just, maltreat people. Doesn't know how the rest of his life will pan out. So he should think about that. So that's what I'm saying. There's book law, okay, contract. Then there's also practical sense. He should be civil. He should be humane. He can't impose that, that clause. The final sentence of this is that, listen, the debt can only, be extinguished under what we call limitation of actions. So if somebody owes you, normally, of course, there are so many exceptions, we can't go into them, but the general rule is that you have a period of 6 years. 6 years to sue. So, unless those 6 years, and as I said, there are exceptions. Perhaps the exceptions can apply, but we don't have time on this forum to, go into that. So what I'm saying is that number one, can't unilaterally say if you don't come and verify or validate, you lose your claim. You can't do that.
Martin, real quick, the final issue that we want to touch on. Number one has been on bail since 2019. Prosecution is waiting for AG's advice. How should customers understand, what's happening with the prosecution? There are people who have compared this with the Jichikwesin trial, for instance, where he's supposed to be going to court every day, and they are raising questions. How is this fair?
Those customers, they've nailed it. When this Jichikwesin came, that was just at that point when AG was fighting for a daily trial. Then I'm also part of those whose minds went to this number one case. Quickly, that was where my mind was. I said, wow, the AG is interested in the daily trial of Jichikwesin when Kwesin's case doesn't disturb the average Ghanaian, especially when Kwesin, it was the EC that allowed Kwesin to contest the 2020 election, especially when the AG didn't charge EC. When EC looked at the case and with the advice of his lawyers, EC thought that no, Kwesin could stand. AG didn't add EC. AG didn't charge EC and was yet interested in Jichikwesin's trial and wasn't interested in Namwan's case. So those people have something to say, and I support them fully. This is the case that deserves a daily trial, maybe 24 hours a day. Because, look, he's ruined people's lives. Mama, are dying. The hunger in the system is no joke. There's so much despondency. People are hungry. People can't pay their bills. These customers are going through hell. And the Attorney General is not interested since 2019. You see it? Yet, Kwesi's case that even the people of Asen have voiced their their mandate. They've made it clear that they want him to be an MP. And so, ordinarily, that would mean discontinue the trial. AG is interested in that one and not interested in a case that affects people's daily lives. So those people have something to say. And I support them 125%.
Well, Martin, we'll leave it here because we've talked about it. Let's see what the regulators would do from here. Thank you so much for your time here on the Super Morning Show.
You're welcome.
And that's Martin Kpebu. He's a private legal practitioner talking to us on this NAM1 issue, the latest development with what he's put out in terms of validation of customers' debts.